Welcome to Life, Death, and the Law, presented by the law firm of Beeson, Garner, and Hansen, hosted by attorneys Shawn Garner and Adam Hansen.
Welcome to another edition of Life, Death, and the Law. I'm Shawn Garner, attorney with Beeson, Garner, and Hansen, and we are in studio here with a couple of guests. We have Savannah sitting to my right. She is my office manager and someone who makes things go very smoothly in the firm, but I take all the credit for everything that she does. Welcome, Savannah.
Always, right? Good morning.
And then we have Anakaren sitting across from me, and she is going to help with the production and make sure that we sound good and look good on our YouTube channel, as well as over the radio and the podcast. And then directly to, in front of me to my right, we've got Cody Beeson. Welcome, Cody.
Good morning. How you doing?
So, Cody, we want to start out the morning and with a little bit of humor. So what do you got for us?
Hey, well, thank you for allowing me to plug, the 928 comedy shows. We had a sold-out show last week with our
congratulations.
Comedian yet. Thank you. I appreciate it.
Well, who was the biggest comedian yet?
Willie Barcena. He's on Prime and Netflix and Showtime. Like he wanted to come down here and do Yuma. So
who organizes this? Are you the organizer?
Yeah, pretty much.
Okay, and your company is
928 Comedy.
So for those of you that want to put on an event and have a comedy event, call 928 Comedy.
Oh, I guess we could do that. Yeah, I just do my own shows, but I guess we could do that for other people too.
Like a quinceañera or a...
Yeah, if you want one at your quinceañera, we do that.
I don't know. Do they have comedy event? I haven't been to a lot of quinceañeras.
No, sir, we do not have comedy.
Oh, okay. All right.
I mean, that will be a change, but no.
Okay, well, if you're just having a fun party and you want some laughs, call 928 Comedy, and Cody Beeson's your man.
Or come to our next show, Alex Hooper at the Crest.
Okay, what day?
June 16th.
June 16th, Alex Hooper at the Crest.
Tickets on sale.
Great.
All right. But thank you, though, because on Friday I started with this one, and it basically, because I learned, you should tell people about yourself. Use that 5 minutes to tell them something honest about you. And honestly, I'm a dog person. I'm a dog person because I don't have kids, and I don't want kids. That's a lot of responsibility. You guys have kids, and you're on the hook for life. All right. When I leave, I can keep my dogs in a kennel. You can't do that with your kids. There's a phone number people call if you do that. Right?
You can't tell people that you do that.
We celebrate Dog Christmas, which is like a couple days after normal Christmas when everything is 90% off.
Yeah.
Yeah, dogs don't know what a calendar is.
Well, that's awesome.
You can't do that with the kids. You're going to scar them for life if they have Christmas on the 27th.
I've tried it. Doesn't work.
Right. Anyways, you can spend so much effort and energy and do everything right for your children, but then they spend too much time at grandma and grandpa's house, repeats grandma's word for Brazil nuts. Now you're responsible for raising a little racist.
Okay. Yes, and I was going to say a comment about that, but I'm not going to.
Don't need to.
So, Grandma and Grandpa can always be counted on for all the things that we get blamed for the way our kids are raised. But you know what? They did a pretty darn good job with me. So, what can I say?
Yeah, right.
I want to move on and talk about a little anecdote. One of my all-time heroes is Abraham Lincoln. Now, I like history. I wouldn't say I'm a history buff because I have a terrible memory. I read a lot of history, but I have a hard time calling it to memory when I need to. But I read a lot of Abraham Lincoln about his life and biography. And so I want to start doing a quote from him on a regular basis. This isn't actually a quote, but it is a story near the end of his life that he encountered and was written down about him. It's about John P. Hale, who had been one of the few Republicans in the Senate during Abraham Lincoln's presidency who was flat out abolitionist. Now, we take it for credit now that Republicans were the abolitionist party back in the 1860s. But there were a lot of people that had reservations about being very adamant about abolition, getting rid of slavery. The Democratic Party was pro-slavery.
They were forming the Ku Klux Klan at the time.
They were. And in fact, the Ku Klux Klan was formed by a Democratic leader. However, all that's kind of lost to history, and ironically so. But this person, John P. Hale, his catchphrase was free soil and free men. And he was an unapologetic abolitionist. And so when President Lincoln was going into his second term, he asked President Lincoln he didn't get reelected, by the way. He wasn't popular enough to get reelected on that stance, free soil and free men. And so he wanted to seek an appointment in the cabinet with President Lincoln. And he wanted to get appointed to become an ambassador to Spain. And he wanted to take his family with him because his daughter was in love with an actor, and he felt that the only way to get his daughter away from who he felt was a bad influence on her, this actor, was to take her over to Spain with him. And turns out the actor was John Wilkes Booth.
No kidding.
So,
Irony.
yeah, so many ironies in the life of the great President Abraham Lincoln. I want to move on and talk a little bit about 23andMe. Speaking of ironies, there are a lot of people who go through the process of adoption, both in adopting children and giving up children for adoption. I love the concept of adoption because it shows that there is an effort to provide for a child who, for one reason or another, life circumstances didn't allow for the natural parents to raise them. And so adoption, I've participated in adoption, and it's been a wonderful miracle in my life. And we've got Savannah on our show that she's also participated in a form of adoption. In a form. We'll get to that.
Okay.
Okay. And so what's coming up and becoming very popular are these searches that you can do with your DNA. 23andMe is a very popular one where you can just take a swab inside your cheek, I think is where they take the swab. I've done it. And my wife bought me a package for my birthday and said, hey, I thought this would be really cool for you. And I'm like, okay, I'm not sure why.
Yeah,
why?
I didn't want a real gift.
Yeah. So, okay. So I swabbed my cheeks, sent it in, and it shows your ancestry. It shows where you're from, your roots, and it's pretty neat to get a deeper connection as to where you're from. And she did it for each of our children too, and fortunately, it showed that I was their father, so that was good.
Was there any doubt, sir?
So we're not going to talk about that, Anakaren.
That's for another show.
Yeah. And so, Savannah, you've gone through a form of this, so I'm going to let you explain what your story is.
So we actually went through artificial insemination.
Okay.
And for those of you that don't know the full process, there's actually two forms when you're actually getting any type of sperm donor or if you're even getting an egg donor, both routes. You can do anonymous, just like you would in a closed adoption where you don't know who that person is and you can't ask for records on them. Then you can do an open one, same way as an open adoption where you know the information. So we went with the anonymous donor. It was my egg, and I carried, and we used a sperm donor. Obviously, growing up, I know that I wasn't going to, my son knows, he's 13 now, he knows it was through a sperm donor. And he says that, he's like, oh, my sperm donor must have been this and that. My sperm donor must have been this and that. So I know he's curious, but it ends there. He is very well loved by both me and we've gotten divorced since, so me and my ex, so no problem. He has two loving households. However, until 23andMe, I never would have imagined that he would ever be able to find out who that sperm donor is. We don't know who it is, so why would he, right? So now, thanks to 23andMe, he can, when he's an adult, search that person up and figure it out.
Yeah, or that person could find him. Mm-hmm. Because if he does a 23andMe search, then and if your son is on that, now you have, I know there are different levels of privacy that you can select on that, but we've all seen that sometimes it falls through the cracks, and it gets exposed that you're related to somebody that you didn't know you're related to, or you've got another child out there that you didn't realize that. We see that in our office when we're doing estate planning on probably a monthly basis. I have a client come in, and I ask them about all their children. And then as soon as they've explained who all their children are, I go a little bit deeper. Well, are there any deceased children that you have? And they'll answer that question. And then I'll ask, are there any children that you're not telling me about? Any estranged children that you'd want to disinherit? We'll go over that, and I'll say, are there any other children? And so by this time, they're like, what are you getting at here? And what I'm getting at is, has somebody done 23andMe and found a child out there, or will they if they do 23andMe or any other? I know there are other companies that do this, but if they do a DNA test and you're in the data bank, are they going to find you as a father? Now, some of them honestly answer no, and then a year later come back and say, guess what? I've got another son out there. I was in this tour in Vietnam, or I was here, there, or the other. And so we need to include them one way or the other in the estate plan, whether it's just acknowledging them that they are a child, but they're not going to receive an inheritance, or providing an inheritance for them. So that's something that comes up often.
Mm-hmm.
Is that something that keeps you awake at night?
Not till recently.
Why is that?
Subject.
Because we have had a case like that.
Yeah.
We had a case where, someone was adopted out, and then after researching, we found out that that adopted child can double dip, right? So they can, if their biological parent who gave up parental rights, they assume there's no more parental rights, nothing to come about it. However, they can come after an inheritance for that. And in the flip side, they can come after the parents who adopted them. If that person passes away, they can also come after an inheritance there. So that's not what concerns me, because, great for the child, they get to double dip. But what concerns me is if people want it closed, or if people want it anonymous, keep it anonymous.
Right. So the reality is sometimes it's not your choice, whether you want it anonymous or not. And if you're going to go on these things, sometimes it's just a gift. It's almost a gag gift. It's like, well, let's see where your ancestors are from. And then boom, a whole bunch of things open up that you didn't know were going to be brought to light, and you better be prepared for it. So you also, estate planning, we're going to do a little plug for that, because that's what we do. That's how we make our bread and butter. We don't make millions off of this podcast like our listeners may think. So we want to make sure that the estate plan is covering all those individuals out there that could potentially claim as a legal heir. Like you said, we are dealing with a case currently where we're finalizing the distributions of that, and they didn't know of this child out there until the last minute, and the child would never have known either. But there was a legal obligation, because we knew when we found it out that we had to notify the child. Under the law, you have to notify all heirs, and unless you've done planning to specifically disinherit any heirs that are the age of majority. So you can't disinherit a minor heir. And it's an interesting thing, because in Arizona, there's actually conflicting laws on that. Under one portion of the law, it says that once a child is adopted, it's as if they were born naturally to their adoptive parents, and their biological parents, their rights are completely severed. And so the biological parent cannot inherit from that child. And that makes sense. However, you cannot sever the biological child's right to inherit from their parent, their biological parent. So just as you're talking about double dipping, they'll inherit generally from their adoptive parents, and they can inherit from their biological parent. And that was the case here. Biological parent passed away. We found out about this biological child out there that had been adopted out, was still a minor. We had to notify the adoptive parents of that minor, and they inherited a sum of money.
Now, here's a question. What if all of this gets, say the whole process of the trust is already gone through, and for some reason this adopted child or this adopted out child is not found? Can they come back and contest, if they found out, say that biological parent was a daddy big bucks per se, and they want now a piece of the inheritance because they're a child, they are their biological child? Can they do that?
Wow, that's I don't know of any court cases like that where the distributions have already gone out, because generally when the distributions are gone, they're gone. Yeah. And so technically under the law, it would be upon the trustee to go back out to the beneficiaries that had received the distributions and call that money back, or at least a portion of the heir and what they're entitled to. So the default under the law for our listeners out there is if you don't mention a child specifically and disinherit them, or you can say it more generally, say all other children that I'm not specifically mentioning here are hereby disinherited. And if you don't state that, then under the default law, they get to inherit the same amount as any other heir at the same level. So if they're a child and you have 4 other children and they're the 5th, they get a 1/5 inheritance. So it's a big deal. That's why it's important to at least make a will and be very specific in the will that says who you want to inherit and disinherit anybody else, whether they're mentioned or not. It's clearer if you don't want somebody to inherit to mention their name. People sometimes feel like, well, that's just pouring salt in a wound. It may, but it may keep you out of court as well. And so it's an important thing to do, at least consider your options. A trust is even better because in a will, even if you disinherit somebody, you have to send notice upon the probate of that will. Wills get probated. For those of you that don't know that, you can't take a will to a bank and get your inheritance. You can't take a will to a closing of an escrow of a house and get your portion of the sale of the house. You have to take the will to the court and have the court acknowledge it and enter it into the probate system and appoint an executor, or as we call it here in Arizona, a personal representative. And then the court requires that all legal heirs, whether they are named as a beneficiary or not, be notified that the will is being probated and give them the opportunity to bring up any issue that they may have, whether they felt like the testator, the parent making the will, was under undue influence by this one child that's getting a bigger portion, or whether they were senile while they made the will. That's the purpose of it. In a trust, it's much different. In a trust, you don't have to notify anybody that's not named as a beneficiary, with the exception of a minor child that's an heir. You can't disinherit the heir that's a minor child. You have a legal obligation to make sure they're provided for as well. At least there are minimum requirements that they are provided for under the statute. We've got to take a break. This is Life, Death, and the Law.
Coming up, more thought-provoking conversations on life, death, and the law right after this.
Hey, Yuma, Dave Ramsey here. If you listen to our show or know anything about us, then you know I only recommend products and services I trust and I believe in. That's why when it comes to protecting your assets and planning for your loved one's future, you've got to call my friends Shawn Garner and Adam Hansen at the law firm of Beeson, Garner, and Hansen. I encourage you to take the first step and attend a free, no-pressure seminar and learn all of your options. The firm of Beeson, Garner, and Hansen has been educating the Yuma community for over 40 years, and this is the only area of law that they practice. Shawn and Adam believe in giving free education to help people make smart decisions about their assets and help them leave a legacy for their family that they can be proud of. Schedule a free personal consultation today. Call 783-4575 or visit yumaestateplanning.com.
You're listening to Life, Death, and the Law, presented by Beeson, Garner, and Hansen, the law firm that has been voted Yuma's best 6 years in a row.
Welcome back to Life, Death, and the Law. I'm in studio here with Savannah as our guest today. She is my office manager, and we've got Anakaren, who is in charge of marketing, and Cody, who is our radio guy, our in-house comedian.
Good morning.
Our local comedian. And he's keeping it lively here. So, Savannah, you've seen most of the cases that go through the firm.
Yes.
Thousands of cases. Any come to mind when we talk about this 23andMe and finding people who you didn't even know about, but now they're related to you and they're an heir to your estate?
Yes, I wanted to take it back to Anakaren's question. What happens if you have an heir out there, but you just can't find them, right? So about the adopted child that we didn't know about, you severed your parental rights, but they are out there and they're a minor. They're entitled to an inheritance since you can't disinherit a minor. Well, there is several situations where we can't find these beneficiaries. They're heirs, they're entitled to something, but we just can't locate them. And that's no problem because there is a system in place for that. Every state has what's called unclaimed funds. And unclaimed funds is something that holds the inheritance. And it's not just for inheritance. Any asset that belongs to someone would go to unclaimed funds. So for Arizona Department of Unclaimed Funds, and they would hold it. In Arizona, they hold it for up to 35 years. They have now, as an heir, 35 years to come forward and prove, I am that person. Give me my money. I've seen it with bank accounts, even when they close bank accounts and, someone forgot they had a bank account somewhere. It was, just sitting there at Bank of America, Wells Fargo. Then they'll send it to unclaimed funds too. So anyone out there, if you want to search unclaimed funds, search your name, see if you have anything out there entitled to you.
And we do that on a regular basis. We do, when we're doing a trust administration, we talk about searching unclaimed funds. I did it just out of curiosity, and I found $1,500 that I had stored in a retirement account from the Arizona State Retirement when I was working as a probation officer 20 years ago. And so it's one of those things. I heard a number just recently. It's $150 billion is currently held in the United States in unclaimed fund departments.
Better look up my name then.
Yes.
Absolutely.
It's funny because a lot of clients say, well, the state's going to take it. The state's going to take it. And yes, funds can go to unclaimed funds, but the state doesn't take it for themselves. They don't want it for themselves. They want someone to go through the probate process and figure it all out for them, right? So a lot of people come in concerned about that. Well, if I do nothing, then the state's just going to come take my house. If I do nothing, all my bank accounts aren't going to my children. The state takes it.
Right. So we often talk about this. We go out into the community, like Cody. We put on shows. They're not as funny. They're not as entertaining.
They're more valuable, I'd say. Keeping people out of court is pretty good.
So we talk to them about putting their affairs in order. And the number one reason why people don't get planning done that we really point out is procrastination. And we have clients that we educate them, whether it's in this neutral location, in a library in the foothills or library here in town, or in our office, we educate them about why you shouldn't procrastinate about getting your estate planning done. And one of my favorite excuses that it is, in my mind, just procrastination, is I need to talk to my kids first. I need to talk to my kids about how I'm going to divide up this house, or how we're going to divide up the rental condo that's in San Diego, or who is going to be my power of attorney. I need to talk to my kids first. And that, to me, if not just procrastination, is a fallacy in your mind, because your kids, you gave them life, right? They owe you everything. So if you tell them that they're going to be your personal representative, they better stand up to the plate and do it. Most of the times, they do. I mean, 99% of the time when we have an estate come in where a client has passed away and the child says, we need to have the will or the trust read to determine who's in charge and who's responsible for consolidating and distributing the assets, the person that we read out their name, this mantle comes upon them, and they straighten their back and they say, okay, I'm going to do this. And even if somebody else comes in and says, if you don't want to, I could do it, they don't. And even if they've got a lot on their plate, they really they step up and they take on that responsibility. So the first lesson that I want to tell people out there, if you think you need to talk to your kids first about this, remember, you're calling the shots still. Your death changes a lot, and your kids will step up to the plate most of the time. And if they won't, if there's a chance they're not going to. Now, life gets in the way sometimes. They could get sick, or they could go through some serious financial or legal trouble. Then we're going to name a successor after them in case they're unable or unwilling to serve. But don't think that you need to have this family powwow and everybody get on the same page before you can get your estate planning in order.
I think they just use it as an excuse, honestly, just so that they don't have to think about the next step, because a lot of people don't like to think about mortality, so they don't want to do that next step. They don't, and then it's like, oh, I have to talk to my kids, because I get that a lot from the Spanish-speaking community. They're like, always have to speak to the kids first, and it's a constant like going back and forth. It's like, why do you need to speak with your kids? It's your estate. But like I said, I think it's just a wall that they build themselves just so they don't have to think about their own mortality.
Bad omen, right?
Yeah.
Like if I think about it, it's going to happen.
Yes.
Yeah. So, Savannah, what have you run across as far as, because you see a lot of clients, and what we do is we collect the first half. We do flat fees. We collect the first half of the fee up front, and then the second half when we complete the work. And some people, they postpone their signing of their plan and coming in and paying that second half. What have you seen? What are some of the reasons that you've come across?
Traveling. So a lot of people, I'm leaving for the summer. Obviously, we live in Yuma, right? Or aside from that, if they're not snowbirds and they're not, they're full-time residents, people take tons of time to take their family vacations. They're this and that. I'm going here. I'm going there. It can wait. Well, what happens if something takes place, unfortunately, during your travel time? Like, then what? You didn't put anything in place because you decided to push it along and say, when I get back, I'll get to it.
What's the typical turnaround right now? I know that we're a little bit backed up because we had an extra busy spring. For some reason, we reopened public seminars this year for the first time in 3 years after the COVID period. And we had an outstanding response to that. We booked out most of our seminars in advance. All the RSVPs were booked out in advance, and then we had walk-ins that we had to turn away. And so we had a lot of people coming out to do planning. We typically like to have a turnaround of 2 weeks.
Yes.
By the time I see them and they come in for their first appointment, we'd like to have the plan signed 2 weeks later. Where are we right now, and how quickly can we get back to the 2 week turnaround?
Yeah, right now we're currently about 5 to 6 weeks out, mainly because of all of those seminars we did. We booked up so much. And we're hoping to, now that the summer slowed down a bit, to bring that back down. If not to the 2 weeks, at least to 3 weeks mark.
Yeah. And now, if you didn't get a chance to watch, what we've done is we've actually postponed some of the seminars that were otherwise scheduled because we want to be able to give a lot of attention to the clients that come into us, make sure that we can turn around and get their planning done rather quickly. 2 weeks is an optimal time for us because by the time they learn about all their options and start implementing those concepts and getting them written down and signed, 2 weeks is enough time to keep it fresh in your mind, and it's not so quick that you feel like you're rushed.
Correct.
And so we found that we've done over 15,000 plans in the community, and we found that that's really the optimal time. You do it within 3 days, people feel like, oh, do I need to sleep on this a little bit more? You do it in 5 weeks, and they forget why it's so urgent, why it's so important to get it done. So we're trying to really get that back to 2 weeks. And so if you didn't get an opportunity to watch a seminar, we don't have one for another 5 weeks planned out there. So you can go online and you can watch our seminar and you can come in and book an appointment. And like I say, we're trying to get closer to that 2 week turnaround. You go to yuma.law and you can watch our seminar. Just as importantly, you can go to yuma.law and you can listen to our podcast, shows that you missed in the past, all the shows that we've done over the past couple of years. You can click on and listen to your favorite topics there. We need to take a break. We'll be back. This is Life, Death, and the Law.
Coming up, more thought-provoking conversations on life, death, and the law right after this.
Hey, Yuma, Dave Ramsey here. If you listen to our show or know anything about us, then you know I only recommend products and services I trust and I believe in. That's why when it comes to protecting your assets and planning for your loved one's future, you've got to call my friends Shawn Garner and Adam Hansen at the law firm of Beeson, Garner, and Hansen. I encourage you to take the first step and attend a free, no-pressure seminar and learn all of your options. The firm of Beeson, Garner, and Hansen has been educating the Yuma community for over 40 years, and this is the only area of law that they practice. Shawn and Adam believe in giving free education to help people make smart decisions about their assets and help them leave a legacy for their family that they can be proud of. Schedule a free personal consultation today. Call 783-4575 or visit yumaestateplanning.com.
You're listening to Life, Death, and the Law, presented by Beeson, Garner, and Hansen, the law firm that has been voted Yuma's best 6 years in a row.
Welcome back to Life, Death, and the Law. We're talking about 23andMe, or in general, DNA testing, and finding out who your family is, who your ancestors are. If you don't have a well-documented family tree, or perhaps you've had some dalliances out there, you might find that your family tree's got a few more branches or roots than you understood. And we see that regularly on an estate planning basis where clients come in and they were certain that they were naming all of their children, and then a year later they come back and say, oh, we forgot about so-and-so, or didn't forget about them, but learned about them. When I was going through law school, we were trying for our third child. Now, I know that in and of itself sounds a bit insane, but it was the right time for us, and we had trouble getting pregnant on our own, my wife and I. So I find that interesting that people always say we, and so I go along with it. She's the one getting pregnant, right?
Yeah, you didn't do the work.
I'm just a step higher than a bystander here in this situation, but we were working on getting her pregnant, and I was participating.
Yeah.
There you go. You got your participation trophy right there.
Yeah, and so it wasn't working, and we went through this fertilization treatment where, she got all these hormone injections and she had to go through this roller coaster of emotions, and we did artificial insemination. And when we went in to do the process, there was a couple other people in there, and one was this very large, bald, hairy guy. And, he comes out from his donation process, and she looks at me and she's like, they had better label those jars.
Yeah.
And I said, well, we'll see.
I was like, we'll see. If the Russian roulette comes out the other way, I don't know.
Yeah. So we went through that process, and we had our third child. And then through medical advice, we were told it's going to be very difficult for you to ever have children on your own, even through this assistance, through this fertilization assistance process. So we resigned to the fact that we were going to have 3 kids, and then the stars aligned. We adopted a 4th child, and after that, she got pregnant on her own. Well, not on her own. It wasn't immaculate.
It's like you weren't a
conception.
bystander,
Yeah,
sir.
Yeah. She got pregnant. And
participated.
So there was a bonus baby. And then 2 years later, or 3 years later, another bonus baby. And at that point, I said, okay, doctor, first of all, you were wrong on whether or not we get pregnant on our own. Now we need to have some intervention here. So that happened. Honestly, I hear that story quite often.
Do you label their Christmas presents bonus baby? Bonus baby 1 and bonus baby 2?
At least it's bonus baby and not uh-oh.
Yeah. Well, my wife and I both have different terms for that. But yeah, so that's what happened with us, and it's interesting because we know that has happened, that there have been mix-ups, and more likely than not, there have been other relationships out there that resulted in children, and these DNA tests are bringing that to light. And so with a DNA test, for a court-ordered DNA test to determine whether or not a father is going to be responsible for child support, Savannah, you said that it costs...
It's $400 in Yuma County, at least. I'm not sure anywhere else, but Yuma County, $400 just to go get a DNA test on that child.
Uh-huh. And 23andMe is like $150 or something like that?
With the extended package, it's $199.
Okay, so I don't know. Why wouldn't they just do a 23andMe? I don't know.
I'm wondering if it has to do with they want certainty.
Chain of custody
and,
type thing. They want to know exactly.
Yeah.
Okay, so
the website boasts that it will find you genetic markers that will that are similar to you. That doesn't mean that they're incredibly related to you. So I think that's might be why they don't go that option.
court doesn't rely on the 23andMe commercial option.
And
Thank goodness.
Yeah.
And the court, of course, when you go get a DNA test here locally, they swab both the parent and the child. So you must have the child there. Yeah.
Okay, that makes sense.
Yeah.
But for $400 to say, yeah, I'm sorry, you have to pay child support. That's,
That is
you know.
your child.
Or on the flip side, 23andMe, $199 to find out, hey, I get to inherit from that person that,
Yeah.
I didn't
The
know I
flip side
had.
is like, yeah, there's a genetic marker here. So now, like, I was like, they're dead. So this is the only thing I got that says, hey, I'm kind of related to them. So do I get something?
Right. Well, there is a law out there that if you haven't established some type of relationship while they were alive, as far as not relationship as in, how are you doing and I'm your kid, but done the DNA test, then that is a type of statute of limitation. So if you haven't established it during their lifetime, that you are their child through a DNA test, then you can't afterwards claim. And so for people that feel like this is going to be an open Pandora's box forever, no, there is a closing point. You do have to do the DNA test while your father or mother is alive to be linked to that person.
I'm sorry, is that just for Arizona or is that a national
That's
standard?
Arizona. I don't know what it is in other states. Yeah, every state has its own law. And Arizona is unique as well as far as whether or not the child gets to adopt from the biological parent. Because in some states, if a child is adopted out, it severs the rights of both the child and the parent. I don't understand how that could be, though, because you can't really sever a child's right, in theory, to their parent who gave birth to them. But legally, it does make things cleaner. And you would think that if you're going through the process of having a suitable parent adopt your child, and the court is awarding that adoption to the adoptive parents, and then that would close the matter. So I see both sides of the argument. I don't know which one is right. I just know what the law is, and that is that you can't sever a child's right to inherit from their biological parents.
That's if they're minors, right? Or is that like
well, that's
point?
total? You can't do it.
Oh.
Once they're adults, then the parent no longer has a responsibility to provide for their care. So they can still inherit as an heir, so you still might need to specifically disinherit them, and you can't disinherit a minor child.
Okay, gotcha.
Disinherit them and their descendants. Because what if that person passed?
Oh,
That's
descendants
true.
are coming forward.
That's
Yeah,
true.
makes
So
sense.
if you're out there doing your own will on, Rocket Lawyer or lawyers.com or whatever it is that's out there now, you got to remember that there are a lot of moving parts about this. And so if you disinherit the child but not their descendants, then what happens is a disinherited child just under the law is treated as a child who's is deceased, predeceased you. And it goes naturally through the law to their children. They call them their issue. And so their children would inherit that child's share. So you've got to be very specific about it's the child and any descendants from that child.
And I've seen that before with the online print it yourself. They come in with their wills. They're like, I already have a will, and it's a 2-page document. I'm like, where'd you get this?
Right.
This doesn't tell me much. And it doesn't even cover, it's crazy how it doesn't even cover, like in Arizona, you have to have a bond if it's not waived, right? And I've seen some printed out and it has no mentioning of a bond.
Yeah, and the bond is a pain in the neck. A bond is an insurance policy that you've got to get, that when you're appointed as a personal representative, you provide an insurance policy with the court that says if you don't handle the assets of the estate properly, the insurance company is going to have to pay all the beneficiaries and potential creditors of the estate what you should have paid using the assets of the estate. And that bond can be expensive, and it can be difficult to get. You've got to have a good credit score to get that. And sometimes that's a deal breaker with somebody serving as a personal representative. They can't get the bond because of some bad credit.
And not just bad credit. Do you know they check for, they ask for your employment history. I had one that couldn't get it. She had good credit, but because she wasn't employed, she was a stay-at-home mom, they denied her the bond.
Wow.
Yeah, I didn't know that about the employment history, because they have to prove that you're going to be able to pay out if you need to pay out.
Yeah, because they're an insurance company, right? They want their money if you're not going to be able to follow through.
So what you're saying is like she was wealthy in means,
Mm-hmm.
but the insurance didn't have any history of her actually working for said means. So like it's like there's nothing to back up that you will be able to pay us back. So we're saying no.
Well, yeah. The credit score is kind of arbitrary in its own right. They use their own logarithm to determine whether or not you're credit worthy. And I know that my wife has a much higher credit score than I do. I don't know how that works, but it's the case. She always does. And so that's how it works. But that's with a bond, that's the case. You've got to go through that credit process. So you want to have your affairs in order. You want, honestly, if you can avoid the court altogether, that's the best. And if you don't want somebody to inherit from you, you specifically name them in your trust and exclude them as a beneficiary in your trust. Only beneficiaries named in the trust get notice of the distributions of the assets in the trust when it becomes administered upon the death of the trustors, the creators of the trust. And in a will, everybody that is a legal heir gets noticed, and that's whether they're a minor or whether they're an adult, whether they were an oops baby or whether they, whatever, they have to get legal notice. And that can be quite a process. And sometimes it's a good thing, and sometimes it opens a can of worms.
It's lengthy. It's costly. It's where there's a will, there's a probate.
Yeah.
That's why trusts are always the way.
I mean, that's when it's published in the newspaper, right? Like the names are in like the legal section.
Yeah.
Is that right? Okay.
So we do that when we can't specifically find the heir, when we don't know where they're located. Otherwise, we give them specific notice. We serve the notice on them that, listen, this is when the court hearing is going to take place regarding the probate. But if we can't find them, then we have to publish it in the newspaper saying, if you're out there, we're having a court hearing this day, and you can come and appear. So it's really putting your business out there to the public.
when it doesn't have to be.
No. Yeah. So with a trust, what you can do, there are a couple options with a trust that does involve a publication. If you can publish that the estate of the individual that passed away is going to be administered through a trust, and if there are any creditors out there, that they can make a claim. So it's not asking for beneficiaries to try to step forward. It's asking for creditors, like, let's say, if there was a car loan, or if there was a credit card loan, or if there was some private loan that was written out, right? It's got to be something that is legally enforceable. Then you can make a claim against the estate. Now, why would you want to do that if you've got a trust that's otherwise private? It's not required under the law for a trust. We give our clients the option to do that because it will shorten the length of the opportunity for anybody to make a claim against a trust or the estate to 4 months as opposed to 2 years. So the default is 2 years, that after the death of the individual, creditors can come back and make a claim. And if you want to just close that box and close that chapter and move on, then we can publish it in the newspaper, and it'll shorten that period to 4 months. So you can distribute all of the assets of the trust knowing that a creditor can't come after the fact and make a claim because they're barred by the statute of limitations.
Mm-hmm. And we have barred them. People have came forward 5 months later or 6 months later stating, hey, this person owed me money. Here's an itemized statement. I'm sorry. You had 4 months. You are forever barred.
Right. And that happens on both sides. So it's one of those things. That's exactly what we want to do with estate planning, is make it clean, make it very possible for them to identify who they want to have their assets, who they want to be in control, allow it to occur privately through their family, and then close that chapter and remember their parent, their uncle, their aunt, whoever it is, for who they were, instead of dealing with a court process and a big, lengthy legal process. That's all the time that we have for today. This is Life, Death, and the Law. We'll talk to you next week.
If you have questions or want to know more about something that was discussed today, please call the law firm of Beeson, Garner, and Hansen at 928-783-4575 or visit yumaestateplanning.com.
Hey, Yuma, Dave Ramsey here. If you listen to our show or know anything about us, then you know I only recommend products and services I trust and I believe in. That's why when it comes to protecting your assets and planning for your loved one's future, you've got to call my friends Shawn Garner and Adam Hansen at the law firm of Beeson, Garner, and Hansen. I encourage you to take the first step and attend a free, no-pressure seminar and learn all of your options. The firm of Beeson, Garner, and Hansen has been educating the Yuma community for over 40 years, and this is the only area of law that they practice. Shawn and Adam believe in giving free education to help people make smart decisions about their assets and help them leave a legacy for their family that they can be proud of. Schedule a free personal consultation today. Call 783-4575 or visit yumaestateplanning.com.